Hello, I'm Disability Attorney Thomas O'Brien, and today's video is titled What to Do While You Wait. A lot of folks after filing for disability wonder what they're able to do in order to help their case, as well as what not to do in order to avoid hurting one's case. Today's presentation is going to cover several such topics. So what we're going to talk about today is both the success rate as well as the lengths of time associated with each level of appeal, ways to potentially speed up an appeal, and things to consider doing as well as to consider avoiding in order to give your case the best chance to succeed. There are three levels of application and appeal that I'm going to be discussing in this video: initial, reconsideration, and the administrative law judge hearing. The initial filing comes with about a 35% chance of success and usually takes about 3 to 5 months to hear an answer. After that 3 to 5 month period, if you're denied, you would then file for reconsideration, which takes about another 3 to 5 months and comes with about a 9% success rate. Do not get discouraged, however. If you can make it to the administrative law judge hearing, your chances increase considerably, as you can see here, to approximately 49%. Unfortunately, the wait for an administrative law judge hearing these days is well north of 500 days. And unfortunately, this presents one of the most significant challenges associated with filing for disability, and that is staying afloat during the time while you're waiting for the judge. Claimants frequently ask how they can speed up their case. Unfortunately, the ability to speed up a case is somewhat limited to 6 very narrow situations. Those 6 types of cases that can be sped up include terminal illness cases. That's where a case is designated critical due to the claimant's illness being untreatable, irreversible, or expected to end in death. The second category is veterans 100% permanent and total disability. These are for veterans that have already received a 100% permanent and total rating from the Department of Veterans Affairs. The third classification is military casualty and wounded warrior cases. These are cases for former military service members or current military service members who sustained an illness, injury, or wound, and they're alleging that that physical or mental impairment is disabling, and finally that they sustained that impairment while on active duty status after October 1st of 2001. The next category is compassionate allowances, and compassionate allowances are diseases and other medical conditions that qualify under as listed impairments. Compassionate allowances are fairly unique and narrow and require extensive medical proof in order to establish their presence. The next category is dire need. A dire need situation exists when a claimant alleges that they're without food and unable to obtain it, that they lack medicine or medical care and are unable to obtain it, and that access to medical care is restricted due to lack of resources. Additionally, a lack of shelter may allow dire need to be considered as well. Finally, the last category is potentially violent. A case may be designated as critical if there's an indication that the claimant is suicidal, homicidal, or potentially violent. Again, most of these determinations, especially the dire need and the potentially violent designations, are made by personnel at the Office of Hearing Operations, and as such, they're subjective. Some of them are not subjective, like the compassionate allowances, as well as the 100% military rating. However, it's important to note that dire critical status, as well as potentially violent status, is not granted in every case and is subject to review. So what should a claimant consider doing while waiting for their case to be adjudicated? Here's a list of several items. O'Brien and Feiler recommends you see your physicians as they direct. That means keeping appointments, making new appointments as needed, and following their orders. However, oftentimes financial pressure interferes with the physician-patient relationship. So we further urge folks to seek care at free or sliding scale clinics to save money. The O'Brien and Feiler knowledge base has comprehensive information about a number of free and sliding scale clinics within the state of Georgia. So please visit us online to seek additional information if you're in the state of Georgia. We further urge claimants to communicate comprehensively with folks' physicians. What I mean when I say that is when a physician asks you how you're doing, simply answering fine might be the quickest way to end the conversation. However, if that is not true, you do yourself a disservice by saying that. Rather than answering fine, giving a comprehensive evaluation of the issues that you're dealing with will allow the physician to respond and will also likely result in more detailed explanatory records. It will also help them develop their strategy for treating the conditions that you're seeking care for. I would further urge folks to seek supportive letters, medical source statements, psychiatric review techniques, and updates from their physicians. I highly recommend this. These are worth their weight in gold. When I say updates, if a physician submits a letter early on in your hearing, it is not a problem simply to have a follow-up letter issued by that physician suggesting that their earlier letter reflects the current state of the claimant's condition. That's fully acceptable and reasonable, but it's an additional piece of evidence that would be considered in the evaluation of a case. Further, just know that there is going to be a wait. No matter whether your case gets escalated using one of those special statuses or not, there is going to be a wait. However, that wait is rewarded with improved odds. Hang in there. I know it's difficult and I know it's a challenge to get treatment when you don't have any money coming in, but I would urge you to do your best to hang in there. Additionally, see if you qualify for TANF and food stamps. Those can offer families assistance during their times of need. Finally, for additional comprehensive information, including forms, judge statistics, as well as good general advice, please visit the O'Brien and Feiler knowledge base. The information there is free and it's helpful. So while there are several things that claimants should do, there are a number of things that claimants should not do while waiting for the adjudication of their case. First of all, we would strongly recommend not letting the SSA doctors provide the only insight into a medical condition. The Social Security Administration will send a claimant to their physicians or their psychologists for evaluation, especially if there's not a generous amount of evidence already on that subject in the case file. SSA doctors, in my experience, historically do not necessarily provide very favorable information, even if the claimant is in dire need of medical help. Letting them provide the only insight or evidence on a specific medical malady will be problematic, potentially, during the adjudication of the case. I would further urge folks not to dwell on treatment received years before the onset date. Oftentimes, folks apply based on some serious medical malady that occurred years in the past. While evidence that that malady occurred may be helpful, evidence of the specific treatment and impact that occurred years before the onset is not going to be nearly as insightful as new evidence that's being generated as individuals seek care and attention for the medical issues that have occurred in the wake of that watershed moment. I would also urge folks to avoid going the opposite direction of their physician orders. Not following your doctor's orders can result in what's called a label of non-compliance by your doctors, and I will say that the word non-compliance is very unfavorable with regard to Social Security's evaluations of individuals. If they see that you are non-compliant with physician orders, that may well provide ammunition to support declining benefits. Additionally, self-medicating, using alcohol, illicit substances, somebody else's medication, all of those items, I would urge you, please, please, please do not do this if you want to receive Social Security benefits. There's a very, very quick way to derail a case, and self-medication is one of them. Additionally, not seeking care or discontinuing treatment can cause issues. I understand, as we discussed previously, that there's often financial pressure with regard to seeking medical care. However, do your absolute best to seek out a free or sliding scale clinic or a charity care program through an area medical group or hospital that will offer you care. Even if it's not the comprehensive care you want, any care is better than not seeking care whatsoever. And finally, a lot of folks wish to work while they're waiting, and that's not necessarily a bad thing, but be mindful of what's called SGA, or Substantial Gainful Activity limits. SGA limits in 2018 are $1,180 per month, and know that those are gross earnings. That's not net earnings. You want to earn less than $1,180 a month unless you're blind in which case the limit is somewhat higher. I would say that it is wise if you're volunteering to keep your volunteer hours probably below about 20 hours a week, preferably a good bit below that as well. I understand there's generally not payment when you're volunteering. However, volunteer work can still often very much look like work during an evaluation. I hope this video has been helpful and insightful. I do understand the position that claimants often find themselves in, which is to say, I'm now out of work, therefore I have trouble affording the basics of life like food, shelter, and clothing, much less additional medical care or medicine. However, I will say that if you're able to weather the application process and seek care during that process, you give yourself the best chance to succeed. As you saw from the graph earlier in the presentation, the odds increase as you continue down the application process and appeals process. We urge you to hang on, to do your best to seek care at a free or sliding scale clinic, and do your best to get local expert counsel. If you're in Georgia, O'Brien and Feiler would like to help you. If you're elsewhere, we would be happy to find you a local expert, but definitely do yourself a favor, especially if you have a hearing in your future. Seek local expert counsel that specializes in Social Security disability. As always, please feel free to visit us online at obflegal.com. Our knowledge base, as well as OBF TV, are free to use, and they're chock full of helpful information, including forms, directories, judge statistics, and a whole bunch of other information. I look forward to hearing from you, and good luck to you.